In this video, I want to chat a little bit about the rights that copyrights provide and some of the exceptions to those rights. To start, I want to remind you that copyright protects original works of authorship. Original means that we are talking about independently developed creativity. And works of authorship include, well, the sky is pretty much the limit. I read the laundry list to you before, but recall that it includes literary works, dramatic works, choreographic works, paintings, photographs, movies, architecture, you name it. But the one I want to spend a little time on here, because I think most of you are probably interested in it, is music. And music is insanely complicated. So I just want to give you a feel for some of the difficulties that music raises with copyrights. To begin, think about how music is recorded and developed. The first step might be to come up with a melody and then write down the notes for the musical arrangement. You also might add lyrics that are intended to accompany the song. So we'll call the arrangement, along with the words, if there are any, the composition for the song. And clearly, the musical composition may include lots of artistic creativity that deserves copyright protection. Now, let's say somebody wants to record a performance of the musical composition. They want a lead vocalist to sing the song with a live band, for instance, and they want to make a sound recording of the session. And so there's also going to be a lot of artistic creativity in that particular recording with the vocals, guitar riffs, and drum beats, even with how the session is mic'd and tracked. And this creativity on the sound recording deserves copyright protection as well. Thus, when you have a recording of a song, you need to simultaneously think about it in terms of the original composition that comprises the melody and words, and the performance by the musicians that was recorded on the tape, CD, or digital drive. And yes, whenever you do anything with recorded music, you have to make sure that you suitably address the interests of not one, but two copyright owners. One for the composition, and the other in the performance embodied on the sound recording. And we'll see in a moment how this can complicate matters whenever you want to include music in anything that you may want to do. On this slide, I have listed the essential rights that a copyright provides to a copyright owner. And the very first is the right to reproduce the copyrighted work in copies. Given the name, copyright, I'm sure you expected the right to make a copy would be here. So one thing I just want you to note now, and we'll go over it later. You don't have to make an exact duplicate to reproduce with copyrights. Rather, you reproduce a work when you use it to make something that has substantially similar expression. Next on the list is the right to make derivative works. Think of these as adaptations based on the copyrighted work, such as adapting a book into a play or a movie, abridging a long novel, translating a textbook into another language, or making a sound recording from a musical composition. So nobody can do these things without the copyright owner's permission. Next, we get to the distribution right, or more precisely, the right to distribute copyrighted works to the public. So, yes, if you possess a copyrighted work, you may not be able to sell it unless you have permission, or unless there is a limitation that otherwise allows you to sell it without that permission. The next item is the right to perform a copyrighted work publicly. That would be like playing music over the radio or streaming it via the internet, or showing a movie at a theater or over the web. In a similar fashion, the copyright owner in an image has the right to display it publicly. For both performance and display, the concept of publicly means that it is shared with more than a normal circle of friends, or in a place open to the public. Thus, if I rent a movie, I can show it at home to several of my friends, because the performance of the movie is not made publicly. But if I want to show it at a club meeting, then all bets are off. The same thing applies with an image. If you purchase a painting, you can hang it at home. But if you want to display it in an office lobby, be careful. Same warning if you want to post a copyrighted photo on your website. I'm not saying it's necessarily illegal to do these things without permission, but you do have to consider if you are violating copyright interests whenever you display a work to the public. Given these basics, I want to get back to music for a moment. Let's start with a musical composition. That would be the basic notes and words that are written down in some fashion. Now, assume a folk singer likes the song and wants to make a recording of it, perhaps on a CD or in a digital file. For her to do so, she will, in a sense, have to adapt the composition into her sound-recorded version, or in other words, make a derivative work. This means that she will need permission from the composition copyright owner to make her sound recording of the song. She will obtain this permission through what they call a mechanical license in the biz, and she will likely pay a fee, sometimes just called a mechanical, for the right to record her version of the song. The same principles apply, by the way, if she wants to make a cover of a song that has already been released. Again, she will need a mechanical license to make her recorded version that is substantially similar to the original composition. Now, once she gets permission and records the song, she will now be adding her own creative vocals and instrumentation to the original composition, and both are fused into the new derivative work, which is the sound recording. And so now both artists have copyright interests in the creativity embodied in that sound recording. The composition copyright owner still has rights to the melody and words, while the folk singer has rights to her singing and playing. Just to get you started on how complicated this could get, assume that a music distribution company wants to make copies of the sound recording and sell them to the public. To do that, the company will have to get permission and thus pay separate licensing fees to both the composition copyright owner and the recording artists. It will need to get a mechanical license from the composition owner to make and distribute each physical or digital copy of the sound recording because it is based on the original song. The company will also need permission from the musical artists and studio technicians to reproduce and distribute each copy of the sound recording because they include their copyrighted creative contributions as well. Let's move on to the right to perform publicly, which is obviously also pertinent to music. For starters, let's assume that I am a disc jockey at an FM radio station and simply want to play a track from a sound recording. So I will be performing the song publicly, which means that I typically would need permission from all the copyright holders to air their creative works. But here's the deal. The Copyright Act states that the copyright owners in sound recordings do not enjoy exclusive rights to perform in traditional ways out loud or over the airwaves. This means that I have to negotiate a license fee with the composers of the composition, but not with the artists who made the sound recording. Now, think for a moment whether you are possibly violating any copyrights when you listen to music from a portable player. So, if you are simply playing music in your house, even with others around you, then that normally would be okay because you're not performing publicly.
But what if you were playing your tunes somewhat loudly at the university union within earshot of students who are not among your normal circle of friends? I believe this would be a public performance, and so strictly speaking would violate the copyright in the composition, unless it falls within some exception. Now, I don't think anyone's going to come after you for doing this, so I wouldn't be excessively worried. But it's good to start thinking about the potential wide reach of the laws. You also might wonder if some exception in the law might legitimize this very common behavior. Off the top of my head, I'm not too sure. Maybe fair use, but I don't really think I'd bet on it. Just to take this a step further, what if I'm giving a spin class at the rec center and want to play motivational music during it? This is definitely a public performance, and it's a planned activity with a commercial purpose. So this might be a sensible target for the composition copyright owners, unless some exception or limitation applies. Thus, if I am ASI counsel, I would definitely want to look into this further, and perhaps pay required licensing fees for selected tracks. Okay, as I mentioned, you don't have to pay fees to the sound recording copyright owners for over-the-air musical performances. In their minds, this used to be just fine. The broadcasts were like advertising, which motivated listeners to go to the store and buy a CD, and that's where recording companies would make their money. But with the advent of digital streaming, especially when you get to select the tracks, as on Spotify, they realized that customers may no longer need to buy CDs to hear what they want. As is becoming increasingly typical, the changes with technology had now jeopardized the financial model that had worked well under the old regimes. And so the recording companies lobbied for changes to the law that gave them rights to performances that were delivered by digital transmissions. Okay, so all of this gets very complicated, well beyond the scope of what we're doing here. But now, when broadcasters and internet music companies stream music, they will invariably have to pay license fees to both the composition and sound recording copyright owners. These may be negotiated, but as I'll mention when we review limitations next, sometimes the law provides for established compulsory licenses that the copyright holders must accept unless they work out a different arrangement. And the availability of compulsory licenses and the required performance fees may depend on how much control the customer has over selecting the content. This gets down to whether the service is interactive, such as Spotify, or something like the free version of Pandora that plays relevant songs within a genre. And trust me, it gets even worse, because interactive sites may not only have to pay performance fees to the composition owner, but mechanical fees for the distribution of selected tracks as well. Frankly, it's just a convoluted mess. But if you are involved with writing or recording music, then there are plenty of people out there to help you. For instance, composers often have agents called publishers that can help them deal with getting these permissions and getting paid. Then there are performance rights organizations that facilitate the collection of fees for public performances. You may, for instance, have heard of ASCAP or BMI, which are two prominent organizations that do this. There are also agencies such as Harry Fox that help composers collect fees for mechanical rights. And if you make a sound recording, there are organizations that can assist you with this as well. Sound Exchange, for instance, works to collect digital performance fees for sound recordings. Well, that's enough. about all this. Just realize that when you simply download or stream music, there's a lot going on behind the scenes that allow it to legally happen and for participants to get paid. And my goodness, if you're making a video or a movie that you want to include pre-recorded music, then it gets even more complicated because now you are syncing the music with the images. And then you will be performing the music when you show the movie to theater audiences or others. And as always, both the composers and recording artists have copyright interests that need to be addressed. Okay. I'm going to move on now, I promise. I already mentioned how the concept of public is defined for copyright purposes. Basically, are you showing or transmitting it to more than a normal circle of friends? Those of you that have used services from Dish Network may have heard of Sling, which is a feature that lets you watch live television programs outside of your home on your computer, iPad, or smartphone. Essentially, what Sling does is it takes the TV signal that comes to your home and then retransmits it to your personal device when you're on the go. It's a great feature for sports fans who want to watch a game, but who are not at home to see the live broadcast. The question is whether the retransmission is a performance of the copyrighted TV content in another location. Because if so, then you might need permission from the copyright holders before doing it. And yes, it is a performance, but it's not a performance that is made publicly, since you are transmitting it solely to yourself. Thus, you can do this without stepping on copyright toes. You might also be able to give access to a few of your friends and not violate copyrights. But if you shared it more widely, then you might cross the line. Now, this is getting a little ahead of ourselves, but think about this. Sling is a technology which has lawful uses, but it also might be used to violate copyrights. The issue is whether Dish Network should be held responsible when those few abusive customers use Sling unlawfully to make public performances of TV content. And so we will see that the answer very likely will be no in this instance. But again, I just want you to hold on to this thought. All right, I raised the notion of exceptions and limitations before. So now I want to delve into that topic a little deeper. And trust me, there are a lot of limitations, especially for performances. And I don't know all of them off the top of my head. But I do know that anytime an action violates one of those very broad rights that copyright owners enjoy, I need to then look at the limitations to see if the behavior might nonetheless be lawful. So what I'm telling you is that I know to always look, and I know where to look. That should be the rule for you and your attorney as well. I put the first one, fair use, in bold because it is by far the most sweeping and important. And we're going to spend a lot of time specifically addressing it later. So for now, let's just skip over it. The next one on the list is the first sale exception. This is the provision that lets you sell your printed textbooks when you are done with them, even though, strictly speaking, the Copyright Act states that you can't distribute copyrighted material without permission. To be a little more precise, the limitation states that if you own a physical medium, such as paper or a CD, and it contains copyrighted content that was lawfully placed on it, then you can distribute the physical item with the included copyrighted material to someone else, and you can do so without consulting the copyright owner. Now, I have to hesitate here a little because if you rent or lease the item, then the exception does not apply, and instead you must follow the conditions in the rental agreement. Still, I want you to recognize that when you purchase or obtain common copyrighted materials, such as books, sculptures, or paintings, you can resell or give them away whenever you want. So, here's an interesting issue that came up relatively recently. Due to the first sale doctrine, I can always sell CDs in my collection that I don't want anymore. Thus, if somebody gave me a Billy Joel CD for my birthday, which I definitely wouldn't care for, I could immediately sell it to somebody who might want it. The same is true of all my other CDs that I no longer play. But, I purchased most of my recent music by downloading the songs to my computer via iTunes. What if I want to transfer those files to somebody else who might enjoy them? Can I do that without permission? The problem is that the files reside on my computer, and strictly speaking, I can only distribute the files along with the physical media to fall under the first sale exception. Thus, I might have to sell my computer for this to work. Well, a company called Redigi came up with a technology which enabled sales of digital music that it thought complied with the first sale exception. And we can talk about this later if you want, but the music industry sued Redigi, and Redigi lost. Moving along, I want to point out that there are special exceptions in the Copyright Act that apply to computer programs. One thing you might worry about when you purchase computer software is that the file may become corrupted and your program thus may no longer work. You could solve this problem by making a backup copy of the program so that you could reload it if something happened to the original. But to do so, you would have to reproduce the copyrighted material, and that's not normally allowed without permission. Well, a special section in the statute provides that you can make that copy without consulting the copyright owner. Okay, well then you might try to play clever and someday sell the original, but keep the backup. But the drafters thought of that and prevented it. Either you have to destroy the backup when you sell the original, or you have to sell them both together. Another problem with computer programs is that your computer actually can't use them unless they are first loaded into random access memory, which requires a reproduction of the copyrighted code. Do you need permission to use the program that you just bought? It's silly, right? But once again, you can see how digital technologies can challenge old laws. Anyway, Congress updated the Copyright Act to allow these kinds of copies that are necessary for the programs to operate in the machine. And there are some other similar exceptions for computer programs as well. Okay, continuing on, there are a slew of very specific exceptions for several kinds of public performances and displays. A number of them have to do with educational uses of copyrighted material. For instance, if I wanted to show a movie in class, that would be a performance to the public, and so ordinarily I would need permission, unless it fell within an exception. So the activity might be a fair use, but that's always a little dicey. However, there is a specific limitation that allows me to play the movie on site to my students as long as I obtain the copy of the movie lawfully. I also can show it remotely with numerous caveats. Oh, then there's TV. You probably never really thought about this, but can a bar turn on TVs so that customers can watch sporting events while in the facility? Strictly speaking, that is a performance of the copyrighted broadcast in a place open to the public. But there is a specific exception that allows the bar to do this without nailing down specific permissions, but under very strict parameters based on the purpose and size of the facility, the size of the screens, and the number of locations of the speakers. Okay, well, how about displaying paintings at a public art exhibition? Can a gallery do that without seeking permission? And, of course the answer is yes. And the reason is that there is an exception that allows one to make a display to people that are located within the facility. The same is true for that artwork that you display in your office. Okay, I just want to rattle off a few more limitations that might interest you. So here's one. Architects have copyright protection not only in their blueprints, but also for certain creative attributes of the completed buildings that they design. So let's say you were walking down the street and take a picture of a modern home that you think is stunning. Whoops! You probably didn't consider that just by recording the image, you've reproduced a copyrighted work. And then you might further engage in violations by distributing or displaying that photograph. But there is a limitation that protects you from infringement as long as the photo is taken from a place where the building is in public view. This, by the way, is what allows Google to take its photos for Street View without having to negotiate with architects. Having said this, if you have to travel up a private driveway to take the photo, then you're on your own. I know we've spent a lot of time with music, but I do want to mention an important kind of limitation that the Copyright Act puts on certain music-related copyrights. These are called compulsory licenses, which basically allows someone to use a copyrighted work without face-to-face negotiations, as long as a required fee is paid. Let's say, for instance, that you want to make and distribute a cover, that is your own version, of a song that the composition copyright owner has already released as a recording. You can do this without seeking permission, as long as you pay the statutorily defined mechanical license fee, which I think is currently around 9 cents for each unit made. There are also some basic requirements that you must follow, such as sticking to the spirit and style of the original. Digital streaming and download companies can also benefit from compulsory license fees. For instance, music sites can pay set mechanical license fees to composition copyright owners when customers download their works. Streaming is a different story, however, as the sites must negotiate public performance fees with the songwriters. Having said this, companies involved with interactive streaming must also pay a mechanical fee on top, but they can do this with a compulsory license. Compulsory fees can also help a little bit with addressing the interests of sound recording copyright owners. For instance, companies making non-interactive streams can pay a statutory rate to sound recording companies. This would be like free versions of Pandora or internet radio sites. However, companies such as Spotify that enable interactive streams have to individually negotiate licenses with the sound recording copyright holders. In addition, companies that enable digital downloads, such as Apple with iTunes, must reach their own agreements with the sound recording interests. Look, do I care that you fully understand or remember all this music stuff? Absolutely not. As I said before, I just want you to see the challenges that face those involved in the business. 2 copyright holders, permanent downloads, interactive or non-interactive streaming, mechanical license fees, reproduction fees, performance fees, digital transmission fees, compulsory licenses. It just goes on and on. If you are interested in music, all I can say is hold on to your hats. The final items on this list are not really exceptions or limitations at all. I only put them on here because they represent another avenue that smooths the road for someone to use a copyrighted work. So here's the deal. The copyright owner is basically telling you up front that you have permission to do certain things with a copyrighted work. The first method is through a really cool arrangement called Creative Commons. We can go to its website, as I've done here at creativecommons.org, which does a really good job explaining what Creative Commons is and how you might use it. So I'll just scroll down here a little bit, but if you haven't been here before, you might want to go and actually visit yourself and just read a little bit about it. So anyway, for instance, you now understand the incredible thicket of copyright protections involved with music and the hassle it creates for those who may want to build on pre-existing works. Indeed, if you were to ask, you might learn that many copyright holders in music wish there weren't so many roadblocks and would actually like to encourage others to add vocals or instrumentation to their works, or incorporate them into new projects. And so Creative Commons provides a simple mechanism for copyright owners to automatically allow others to use their copyrighted materials in certain identified ways. So, for instance, suppose you create a violin track and you think, wow, I bet this would sound great if other musicians made their own tracks and mixed them with it. However, they might fear doing so because the combined work would be a derivative work which they can't legally make without your permission. So you want to let them all know from the start that you do give this permission to make and distribute derivative works. But beyond this, you might only want them to be involved if they will likewise permit others to build on their additions in the same way you just allowed them to work with yours. You also may want this to be an entirely non-profit endeavor, and so don't want them to have commercial objectives. And of course, you probably want to be credited for your contribution. Creative Commons provides a shorthand way for you to indicate what freedoms you are providing with the work, based on your desires about 4 parameters. First, there's attribution. Then there's making derivative works, allowing for commercial use, and whether the new work must afford the same freedoms, which they call share alike. So, based on your choices about these parameters, you can select among several Creative Commons licenses that extend your wishes. These are fully explained on the website, and I really encourage you to someday take a look at this and see how it all works. And by the way, this is not just for music. It also is used with photographs, videos, educational materials, and other kinds of works. So, Creative Commons, some rights reserved. Check it out. Those of you who are involved with designing software are probably familiar with something similar in the programming field called open source software. There we go. Open source software is distributed with a license called the General Public License that provides others the freedom to adapt the computer program with some specified limitations and requirements. So it's like, here's what I've done to date on this program. you can build on it and use your new version in your facilities. You also may distribute your new work, but if you do, you must give the recipients the same privileges I gave to you, meaning that they can continue to adapt and redistribute the program. This is called open source because it automatically allows others who obtain the program to use it, build on it, and redistribute it without seeking permissions to do so.
Okay, there are many more exceptions, but I think you get the idea. I have to tell you that there's increasing tension with copyrights. The old laws often don't appropriately address the issues raised with new digital technologies. This is why Congress steps in and makes these exceptions. But Congress moves slowly, if it moves at all. So when there are problems that Congress hasn't yet addressed, the only place to look for help is with fair use, which gives courts the flexibility to allow new uses when they seem reasonable under the circumstances. If you ask me, the most important copyright topic for tech companies right now is fair use. So don't be surprised that we're going to spend a lot of time with it. And this is the topic I plan to introduce next. Until then, have a nice day.